to advanced trial tactics. How do you get those punitives? And this is punitive damages as to business torts. And today we have back our dynamic duo, which is our beloved Malcolm McNeil, a BHP's past president on so many boards, and he's had an illustrious career and just a great guy. So Malcolm has over 35 years of litigation and commercial experience in a wide variety of matters, including business, commercial, construction, employment disputes, administrative proceedings, trade secrets, probate, media and entertainment, intellectual property, partnership disputes, and real estate. Malcolm has over 25 years in resolving civil disputes as a mediator and a panel mediator of the United States District Court, Central District of California, as well as having a very admirable international practice. Malcolm has litigated issues for a variety of businesses, including those in venture capital formation, retail, entertainment, textile manufacturing, import-export, real estate investment, aviation, and publishing. He is keenly aware of the legal and business needs that enable his clients' business to keep moving forward. He also has experience in cross-border negotiations, has had an established network of colleagues globally, assisting foreign countries as needs arise. Malcolm's practices include representing clients in most forums, including a range of administrative court, statewide and nationally, and internationally as well. Known for his leadership and accomplishments, particularly for clients with business interests in China, Malcolm is a panel member of the Shenzhen Court of International Arbitration, the Beijing International Arbitration Commission, and the Harbin Arbitration Commission. Malcolm serves as the co-leader of Aaron Fox's international group and is as we know, past president, one of our past presidents. And Lynn is a partner at Aaron Fox, and she and Malcolm have tried several cases together. Lynn heads up one of the several departments in Aaron Fox's San Francisco office with often trips to Los Angeles, and is also the co-leader for the firm's consumer products industry group. Besides her knowledge in the subject matter, she's co-chaired and handled cases involving these issues with Malcolm and other attorneys. And her experience runs is broad and runs a broad gamut of sectors and industries. So I'm going to turn this over to Malcolm and Lynn promptly. Malcolm and Lynn, we're really looking forward to tonight's presentation.
Well, thank you for that very generous introduction, Hillary. That's wonderful. And yes, first of all, good morning, good afternoon, or good evening to you, wherever you may be when you're watching this program. Yes, it's Lynn and I's both our honor as well as our lots of fun time to work together to talk about these topics that we hear about as lawyers, but we don't always know exactly how they interplay in actual practice. Our last program actually was a one session program, which we ended up breaking into 2 sessions on B&P Code Section 17200, and that's because of the density of the material. We had a lot to go through and wanted to make sure that we were completely explaining those things that would be necessary for you to either present or defend a 17200 claim. So guess what? As we put together this program on punitive damages and business torts, we started reading cases and said, oh, what about this one? What about this one? What about this one? And the next thing you know, we prepared a PowerPoint, which is comprehensive and formidable. And how that happened is that we're both experienced practitioners, but the real issue is that when you talk about punitive damages with colleagues who have not necessarily had to make the actual plunge into proving punitive damages at trial, there's a lot of mystery around the punitive damages, a lot of lore. You'll hear somebody say that the limitations are 10 times the compensatory damages, 30 times. You'll see an article in the paper saying $65 million reward. And clients have their own opinions about what should be the punitive damages in their given case. So what we tried to do is to put together a program that was going to help you to dissect, both from a plaintiff standpoint and a defense standpoint, the whole concept of punitive damages and how you apply it in court. So I'd like the next slide, please. That's just us. That's Lynn and Malcolm, and how to get a hold of us at some point in time. And this is the agenda for today. The agenda in the first session is going to be what constitutes malice, oppression, despicable conduct, and fraud. The problem when you read those is when you read them together, they sort of blend together and you sort of think of the same conduct. But the cases explained very clearly that each one of those words has a separate connotation and denotation when you're in court, and the evidence to support each one is quite different. The starting point that we're going to go through is establishing the basics through our two jury instructions. That's Casey 3943 and 3945. They're very, very, very similar. So we won't talk too much about the distinctions between the two, but we will talk about what Casey requires that you prove in order to get to the punitive damage phase of your case. Determining punitive damages, that's our third factor. The factors to consider, what strategies you should have as a plaintiff, and finally, what strategies you should have as a defendant to defend against those. And then, of course, we'll open it up for questions. Let's have the next slide, please.
Malcolm, I was just gonna,
Nope.
if I could just add quickly on the agenda, which I'm just realizing it's not on there. We also have a couple of hypotheticals to go through at the end where we can really apply some of these facts that you need to prove punitive damages to the law. And so that'll be interesting to see very different types of scenarios and cases where punitive damages may or may not apply.
No, absolutely, Lynn, and that may be where our viewers and listeners are going to end up, where you'll see a breaking point at some point in the program, because we need to get you through the basics before we get to our examples. But we have specific examples for you, and also specific examples as applied to existing cases. Thank you, Lynn. And since Lynn wanted to jump in, I'm going to let her jump in right now. Go ahead, Lynn. Why don't you start by giving us the basics?
Sure. So just for everybody's edification, and you may remember this code section from prior cases or reviewing the case law, but the basic rule that sort of overlays this whole jurisprudence is in the civil code, and it's section 3294A. And what that section says is that when you have a case not arising from a breach of contract, so here we're talking about business torts. Again, this is kind of an extension of the prior programs that we've done over the last several months or maybe year, whether it's interference with contract or 17200 or something like that, where the plaintiff is able to prove by clear and convincing evidence, that's your standard of proof, that the defendant has engaged in oppression, fraud, or malice, and we're going to get into each of those, what they mean, then the plaintiff, in addition to seeking its compensatory damages, may also recover damages that are there to punish the defendant. We call those punitive damages, as everybody knows. So that's the basic rule. You've got to have malice, fraud, or oppression, or despicable conduct. That's not actually listed here, but that's another factor that can be used. And you have to prove it by clear and convincing evidence. And so that sometimes gets lost in the discussion. We all live normally day by day under a preponderance standard. Most of our cases in the civil world are preponderance standards of proof. Unless you're practicing in criminal law, which if you are, obviously that's beyond a reasonable doubt. Clear and convincing is somewhere in between. And so it is going to require a higher level of proof than just your regular preponderance standard. So this is the basic rule that you want to keep in mind. So I want to break down each of these malice, fraud, oppression, and despicable conduct. If we could go to the next slide, please. All right, so what constitutes malice? And as Malcolm noted, a lot of these terms, malice, fraud, oppression, despicable conduct, they do start to blend. And it's really not until you get into the cases where you can actually see the factors at play and see where there are distinctions and differences. So generally speaking, and this comes out of the jury instruction, malice is where a defendant, whether it's an entity or an employee of a company, maybe it's a manager of a company. We've got a case that we're going to talk a little bit about today, and Malcolm's going to talk about it. It's involving Ralph's grocery store. And in that case, there was a manager who engaged in some sort of unbecoming conduct, if you will. And we'll get into that. But malice essentially means that a company or an employee of an entity acted with the intent. Intent is key here for malice. It's got to be an intent to cause injury to someone else, or that the conduct was despicable. And we'll get into what despicable means, and was done with a willful and knowing disregard of the rights or safety of another. So this term malice really is rooted in intentional conduct, as you can tell by the definition. A willing and knowing disregard of someone else's rights or safety. What comes to mind? Chemical exposures, purposeful. We see these cases a lot with back in, gosh, probably, I don't know if it's the 80s maybe, where we had a lot of the rollover accidents, where it was alleged that the vehicles were purposely designed in a way that subjected the car to roll over, and people were killed or, became paralyzed from these accidents. That's what we're talking about here, that knowing and willful disregard of somebody else's rights or safety. And so it's really just horrendous conduct if you think about it. The person who's engaging in the conduct has to be aware of the probable dangerous consequences of that conduct, and they deliberately fail to avoid the consequences. They know that what they're engaging in is likely to cause injury or death or harm to someone else, and yet they go ahead and they do it anyway. There's going to be a case we're going to talk about involving Roundup, and you may remember the Monsanto company and some of the litigation that went along with that. And I think that one is a really solid example of malice, and we'll get into that a little bit later. All right, if we could go to the slide 6, please. All right, so oppression. What constitutes oppression? If you remember back to the basic rule, you've got to show as the plaintiff either malice, fraud, or oppression in order to demonstrate the recoverability of punitive damages. Again, clear and convincing evidence. So what's oppression? Under the statute, oppression essentially means that a defendant, an entity, a corporation, an LLC, or an agent of a company, an employee of a company, any of those combinations of people and organizations, the conduct was despicable and it subjected the plaintiff to cruel and unjust hardship in knowing disregard of their rights. This is a bit of an overlap with malice in that the knowing disregard of someone else's rights is at play. Whereas with malice, what we saw was the knowing disregard of the rights or safety of specifically the term safety was used. With oppression, the term safety is not used, but the term disregard of someone else's rights is used. And I think, Malcolm, are we going to see an example of this with the Ralph's case? I'm trying to remember if you could remind me.
Yes, well, actually, it's a combination, and there's a case called Gober versus Ralph's Grocery Company, and I think this is a good place to. May I interject on that then, Lynn? Was
Please,
that an invitation?
yes, absolutely.
Great. Gober was an interesting case because there was a manager who was a little bit too touchy-feely and a little bit too belligerent and hostile, and he was a manager of a store. They then called them store directors. And he was transferred from store to store and eventually ended up in the Escondido store. There are 3 sets of plaintiffs that were making claims at different points in time, but they were all joined together for purposes of this case. And what happened was that the Ralph's ended up. They got a huge award against Ralph's. I won't talk about the specifics, but Ralph's, of course, went in on a remitter and a JONOV, and the plaintiffs came back and said that they wanted the awards to be undisturbed, et cetera, and went up on appeal. And for those of you that read it, there's a very complicated procedural history in the case because there were several different post-judgment motions that were going on at the same time. But one of the most important things in the case is that the court talked about the conduct of Ralph's, that it transferred the manager in conscious disregard of rights, but that it was basically a minimal conscious disregard of rights because Ralph's also attempted to take the manager and put him in other positions. They demoted him. They changed his income level to less than half of what he was making as a director. So what the court said is that there were no facts in the case which caused the conduct of Ralph's in placing a manager there to begin with as despicable. And now none of it could be characterized as despicable. And it went on to say that despicable could have meant that if Ralph's placed him in position and they did nothing to change the behavior at any time, then that would have been a different story and perhaps a higher level of culpability. And if there is such a word, despicability in the case. So it gives you a very good example that when you're looking at the facts of your case and you're trying it, is there anything that you can demonstrate as a plaintiff to show that the conduct was despicable, meaning that it was abhorrent, that any juror is going to wince when they hear it? Or on the defense side, you're going to want to show that, no, we took remedial actions. We weren't despicable. What we in fact did was you did steps A, B, and C. And that's the basic and by the way, Ralph's ended up the damages were reduced, et cetera. We'll talk about awards and percentages later. But the point is that the case is very instructive on the issue of what it takes to rise to the level of despicable.
And thank you for that, Malcolm. That's a great example. I think what was also interesting about that case, when we look at the despicability, if that's even a term, of the manager's conduct. I mean, this was a guy who threw a phone at a female bookkeeper. He engaged in conduct. Obviously, he was, accused of making profanities at people, but, throwing objects at people, physically harming them. There was one allegation that he hurled a plastic shield about the size of an envelope at someone's face. I mean, so there's some pretty nasty behaviors going on there. So I think it is factually a really interesting case to look at through the lens of some of these elements, whether it's oppression, malice, or what have you. So thank you for
and let me add one distinction to that too, Lynn. You're quite right. And what the court was doing is it was also applying that standard to what was it that Ralph's knew and what did Ralph's do. I think everybody sort of agreed this manager was a loose cannon, to say the least. And as a consequence, that loose cannon, the question was, to what extent was Ralph's responsible for his behavior, or did they know that he was going to be throwing phones and belittling people and being belligerent and hostile and all of that, including and with all of the normal harmful and offensive touching that we know about in the employment cases. So there's a distinction between what the defendant does and what the entity does.
The knowing piece of it, right, is key, I think, for punitive damages, as we can see from these elements, these just basic elements that you have to prove under the civil code. And we're going to get more into some of that later, but certainly in a case like Ralph's as well, you have patterns of behavior, which becomes relevant to punitive damages. We're going to get into that. These are things just for the audience to be thinking about as we kind of go through the very sort of mundane elements at the outset to getting to really diving in deeper. All right, so that's oppression. Let's go ahead and jump, if we could, to the next slide. So despicable conduct, this is also prove punitive damages. We've already been talking about this in conjunction with the Ralph's case. But if you think about it, it's really any conduct that the average ordinary person would find to be so vile, base, or contemptible that it would be looked down upon by ordinary people, reasonable people. And the examples we just gave, just pulling them right out of the Ralph's case. I mean, throwing objects at other people, profanities, maybe profanities aren't quite as despicable, but you get the idea of something that is just, it's so vile that you're going to be frowned upon by the ordinary citizen. So that's really despicable conduct in a nutshell. All right, let's go to the next slide if we could. And then another way as a plaintiff you can prove punitive damages is through fraud. And we obviously all sort of know what fraud is. We talked about it in our 17-200 presentation as well, because that's one way to prove a violation of 17-200. Essentially, engaging in intentional misrepresentations as a defendant or an employee of a defendant or a high-ranking officer, director of a company. We see punitive damage cases brought all the time where there's conduct that's ratified by an officer or director, and it's fraudulent misrepresentations to a consumer, for example. You know, in the case of consumer products, if you will, there have been a number of cases over the years where a company has, you know, concealed from the public that certain products. I put out there the example of talc. You know, Johnson & Johnson had some very serious awards, punitive damage awards against it. Everybody may remember from the lawsuits over the last many years where it was alleged that the talc products that it manufactured had asbestos in it, and that they knew it, and that the company knew it was harmful and dangerous, and yet didn't warn citizens of that. So that's a clear example of the fraudulent side of punitive damages, and where as a plaintiff, you would marshal evidence to show in discovery, for example, you would want, in that type of a case, you would want to seek historical internal communications going back many, many years when product formulas were being put together, and what kind of scientific literature was reviewed by the company and its epidemiologist or its toxicologist or what have you, to show that the company knew. They knew that this product, for example, had asbestos in it, and that the asbestos could have been harmful to humans, but that they didn't warn the public. That's a clear-cut example of fraud, and there's other ones as well, but I think fraud is probably the most obvious of the punitive damage factors to be discussing. So those are really the key. Again, the basic rule, and then malice, fraud, oppression, and despicable conduct. Were you going to?
Yeah, Lynn, thank you. I just wanted to jump in because I recently completed a case, and it's over, which involved a partnership dispute, and one of the allegations against one of the partners was fraud, that they were stealing money from the other partner. And so I think that's let's say a little bit of a garden variety case that we all run across from time to time that is occurring. It was clear from the facts of the case that the partner who was allegedly stealing was in fact he was tipping the scale in his own favor, but the judge found that the tipping of the scale was more inadvertent and negligent, and found it to be a breach of fiduciary duty, but not a breach of a fiduciary duty that rose to the level of fraud, which was interesting because what that means to you is if you're representing a plaintiff in a fraud case, you want to look at a pattern of misbehavior that shows that you can imply from the nature of the nature of the misappropriation that in fact what happened was that it was done as a pattern. If it's not a pattern and it's an intermittent sort of goofy kind of removal of money from the company, and he was doing different kinds of behavior, the defense side can argue, well, no, it wasn't fraud. He might have been part of the gang that couldn't shoot straight, but it doesn't matter, as the gang that couldn't shoot straight doesn't rise to the level of fraud. So in a business example, I would tell you, look for, as Lynn said, she talked about going back several years in product development. Same issue. You go back several years in the issue in how the finances were divided between the parties, and see if in fact there were specific instructions to the accountant or to the bookkeeper or to whoever, and you look to see, because then you're going to raise the clear and convincing and meet the clear and convincing standard that fraud existed rather than just inadvertent misappropriation.
Yeah, that's a great example, Malcolm. And I think too, just looking at the elements of fraud here on the slide, again, it's intentional misrepresentation. So we have that intent element that is sort of streaming through each of these examples we've given, whether it's malice or oppression or fraud, there has to be that intent there. And again, that's because punitive damages are there to punish. The policy behind them is we want to punish the defendant, and we want to deter this type of conduct from occurring down the road, versus compensatory damages, which we're all used to from our civil cases that we work on, right? Which those are meant to compensate the plaintiff for the harm that he or she has suffered. Punitive damages take on a very different role, and they have a different purpose in our society and in the jurisprudence. So just kind of high level issues to kind of keep in mind. Malcolm, I'm going to put the ping pong ball back in your court if you don't mind to go on to the next slide.
No worries. Thank you. Thank you. Well, here I gave you a preview of this a little while ago, talking about the Ralph's case, and I may in fact talk about it again because I think there's a lot of dicta in the case that is going to be helpful when you're looking back on the evidence presented at trial. So this relates to the punitive damages when you're looking at the employer as against the actions in that case of the store manager or store director. And let's go on to the next slide. Okay. KC 3943, punitive damages may only be awarded against a defendant entity for conduct of an employer agent and only if the plaintiff can prove by clear and convincing evidence that the employee or agent engaged in the conduct with malice, oppression, or fraud. So it's a two-step process because number one, you have to show that they're by clear and convincing evidence, as Lynn has already defined for us, with malice, oppression, or fraud. Next slide, please. Okay, so the plaintiff must show the employee or agent was an officer, director, or managing agent or acting on behalf of the defendant entity, that the entity knowingly employed an employee who is unfit with disregard to the rights or safety of others. Now, that's a very important thing when you weigh it against the facts in Ralph's, because they did find that there was a conscious disregard of the rights of the employees who were injured by the conduct, but they also found that there was not a disregard of the rights or safety of others for the entire length of the conduct by the very fact that Ralph's was taking remedial actions against the manager. So on this second point, Ralph's was able to argue that we did what we thought we should do, maybe not as soon as we should have done it, but we did it at some point in time. And I think we can all glean from that if Ralph's took no action at all against the manager, that the result would have been different in terms of the result against Ralph's. Third,
I have a quick question on that.
Sure.
Sorry, Malcolm,
No,
can I
no
just
worries.
interject for just a
Sure,
moment
sure.
on that second point about the unfit employee? When Ralph's took the remedial action, was there any argument by the plaintiff's counsel that it was essentially an admission by remediating? Do you know what I'm saying? That they were admitting that they were in the wrong, essentially.
Not revealed in the facts of the case, but that question crossed my mind too. Was it, as we know, a subsequent remedial measure, something that could be commented on? But I'll tell you something that was very interesting. The plaintiffs were precluded from showing post-event evidence of misbehavior by the manager because the court reasoned that we review the punitive damages as of the date of the misconduct that took place. And while many of us would like to look at subsequent behavior and say, well, by the way, he went to another store and he did this, this, and this, that evidence was not allowed in. That evidence was not allowed in because the court said, we're going to look at everything from day one of alleged misbehavior up to the date of the action that was taken. But we're not going to allow post actions or post events to come into play and post facts, because that would blur the punitive damage analysis as of the date of the injury. And so that's, I think that was
interesting. I think too, just as a practice pointer, Malcolm, for the defendant, right? If you're representing a defendant in one of these cases and you're going to trial and the plaintiff tries to bring in, or maybe you bring this up on a motion in limine, you move to, exclude any post incident alleged bad conduct or misconduct based on what you were just saying. You try to, at the start of trial, make sure that's not going to come in. I think as a defendant, you would probably want to attack that.
Well, absolutely. And that in the last point here is what was very interesting, because I think the court applied it to Ralph's directly. The defendant entity knew of the employer agent's wrongful conduct and approved the conduct after it occurred. And that was not so fast. No, we took some feeble actions by transferring the manager and giving him some instruction. But then later we said, no. We put them on the remedial program. So they were not found to have approved the conduct after it occurred, even though initially there was conscious disregard of the rights of the plaintiffs. So that's why I like the Ralph's case so much, because it sort of goes back and forth and weaves like a figure eight between the needs that for on both sides, and gives us a lot of instruction for the trial and your trial. And I would advise everyone to read it. So the first two were they were found, let's say, responsible for. The second two, they were found to have mitigated.
Interesting. And that the Rouse case was a California Court of Appeal case?
Yeah, and let me, by the way, since I'm talking about it so much, let me give everybody the citation. It's 40 Cal Reporter 3rd 92. 97 Fair Employment Practice cases, BNA 1181, and it's a 2006 case from the 4th District. So it's relatively recent. Okay, let's go on to the next one. Okay, so how the defendant can contest: show by clear and convincing evidence that the defendant had no knowledge of the employee or the agent's unfitness or bad conduct. Now, this is also interesting in the Ralph's case, because the case goes on to talk about the fact that a couple of the I mentioned earlier that there were 3 sets of plaintiffs, and one of the sets of plaintiffs complained of bad behavior internally in the store, another complained at a different level, and the third never complained. So the court went through a very interesting analysis to say, well, wait, Ralphs didn't understand exactly what was going. They knew that there was some misbehavior that they were trying to correct, but they were never fully advised of the nature and extent of the misconduct until the very last complainants that were complaining and ended up filing suits. So the defendant, it wasn't that the defendant didn't have knowledge, but in the Ralph's case, the defendant didn't have full knowledge of the allegations that were being made by the plaintiffs in the case. So I think that's also a mitigating factor. If you're on the defendant's side, draw a timeline. So you know what? On day 1, we found out this. On day 30, we found out that. On day 90, when we found this out, we said, wait a minute, that's too much. And then we ended up placing him in a different position, put him on probation, terminated him, or whatever. So the timeline, I think, would be critical when you're trying to demonstrate the mitigation of that. And as plaintiffs, if you're doing it as a plaintiff, you want to show that, no, at every step of the way, Ralph's knew. But
again, that knowledge is key, right? The knowledge is really on both sides of the coin.
Absolutely. Absolutely. Let's take a look at the next one. Okay. On this one, want me to toss this one to you, Lynn? Punitive damages against the defendant.
Happy to take this one from you, Malcolm.
Good.
So this is sort of the other, we talked about at the outset, there would be 2 jury instructions we were going to be discussing. This is the second one, and it is very similar to the one that Malcolm just went through. But it focuses more on punitive damages against an entity defendant, and not so much an employer. So if we could go to the next slide, please. This is the jury instruction itself. It's KC 3945, just for your reference. And what it says is that punitive damages may only be awarded against a defendant entity if the plaintiff can prove, again, by clear and convincing evidence, that the entity engaged in the conduct with malice, oppression, or fraud. So very similar to the other jury instruction we just examined together, but it doesn't refer to an employer or an agent acting, under the supervision of the employer. This is really limited to the entity itself. All right, let's go on to slide 15, if we will. This is, again, sort of breaking it down for you, if you're the plaintiff, what you need to show under this jury instruction to essentially to prevail on a claim of punitive damages. Again, you have to, it's always going to be clear and convincing evidence all the way through. So you've got that heightened standard of proof here, which is why the discovery and the facts are so critical. I mean, Malcolm illustrated it with the Rouse case, just talking about the different, in that case you had, harassment that was alleged, there was sexual harassment, there was physical harassment, there was verbal harassment, there was hostile work environment, the list goes on, but it's important to really, as a plaintiff, marshal your facts through discovery in the form of, obviously written discovery, but I think even more importantly, with your deposition testimony that you gather through the parties, not only the parties, but the third party fact witnesses. You know, in the Ralph's case, obviously, there would have been testimony from other people that worked at the store who may have witnessed some of this misconduct going on, so on, so forth and so on. So as a plaintiff, under this instruction, you have to show that the conduct was committed on behalf of the entity by one or more of its officers, directors, or managing agents. So again, we all know what an officer is. Everybody's familiar with the director, but managing agent sometimes has a little bit of a mystery about it in the law. And I recently had this come up in a case, so I've been studying the case law on it. A managing agent is typically someone who is operating on a level within the corporate setting, and that person has the ability to direct and implement corporate policy. So this isn't going to be, you know, someone that manages an ice cream store or manages a gas station or even a restaurant. We're talking somebody at a higher level than that, that is overseeing, you know, parts of the entity, whether it's operations or HR or something of that nature, where they have the authority to direct and implement corporate policy. And that really becomes, that in of itself becomes a question of fact. Is this person even a managing agent? And so the case I had, which is concluded, I was arguing that my client was not a managing agent because he or she did not have the, you know, authority to direct corporate policy. And in fact, the judge agreed with me. And so we were able to get that kicked out on that issue alone. So as the defendant, that may be one of the strategies in attacking the punitive damage claim of the plaintiff under this jury instruction. Nope, they're not a managing agent. End of story. And you can do that. One way you can do that is on summary adjudication or summary judgment, just to give you sort of the procedural vehicle by which it can be done. So you've got to have that. And then the second element is that the conduct was authorized by one or more of the entity's officers, directors, or managing agents. So it wasn't just that someone at the corporate level engaged in this misconduct, but it has to be ratified or authorized by someone else at a high level. And we'll see some examples of that, I think, in the hypos that we've put together for the audience. And then the or is the third element. This is an or, not an and. Or the conduct was adopted and approved after it occurred by more or one of the entity's officers, directors, or managing agents. So basically 3 different ways, if you're the plaintiff, to prove this element of, punitive damages by an entity. All right, we could go to the next slide, please. Okay, and then here, this is the same jury instruction. If you're on the defense side of this, how can you defend? Well, one of the strategies I just pointed out was demonstrating through discovery and depositions that the alleged perpetrator, if you will, was not a managing agent at all. We know they're not an officer, they're not a director, and they're not a managing agent. They're this low level, you know, manager of a small grocery store or a jewelry store or whatever it is, and there's several layers above in terms of the corporate hierarchy. So that might be one way that you can defend against this punitive damage claim that's directed at your client. Another would be to show that the conduct at issue, whatever it was taken, but not by it was not approved by the entity. So someone acted in a way that was, you know, it was vile, it was oppressive, they engaged in malice, but the entity didn't approve it, didn't ratify it. There's no one at the officer, director, or managing agent level that knew about that conduct and approved it or ratified it. So that's another way as a defendant, you can show this was an isolated incident. You know, none of our officers or directors had any awareness about it. We can demonstrate that through testimony, depositions. You know, if you're on the defense side, of course, you want to be sure that your internal communications, your emails are clean of any such evidence of this. That's where I think that's really where in these cases, a lot of the the evidence turns on emails, internal emails, and people don't always stop to think before they send out an email that, 5 years down the road can result in an award of punitive damages or a very high jury award. So if you're on the defense side, you're going to have to really scrub through your client's emails and make sure that there isn't something there that could get you in hot water. But again,
Let
showing
me
that
add
the
to that
conduct.
too.
Yeah, go
Yeah,
ahead, Malcolm.
it's quite right. One of the other ways that the defendant can effectively defend is to point to their own personnel and policies and procedures manuals. That's why you saw so many times that as our sexual harassment laws have evolved and we've modified our employment manuals effectively, you'll see lots of bold language in there saying the company does not condone this type of behavior, and that includes unwanted touching, inappropriate conduct, et cetera, et cetera, et cetera. And the reason why that's there is because then if it occurs, the company is able to say, well, no, we never approved this. In fact, they signed off and got the employment manual, and that's his signature there. And in fact, we enforce it. And then they bring in the HR manager. Oh, yes, we enforce it. As a matter of fact, we took 32 actions last year nationwide against a variety of people, and we had terminations, et cetera. So it's not just a passive provision in our manual, but in fact, we strictly adhere to it. And we hold our sexual harassment courses once every 3 months, and we do blah, 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 and da, da, da. So what happens is that the don't overlook the value of that policies and procedure. Ask your client, have you issued any, if you're on the defense side, ask, have you issued any of those, let's say, periodic reminders of the company's policy, periodic reminders that you should review the policies and procedures once every 6 months, et cetera, et cetera. And conversely, if you're on the plaintiff side, those may be questions you want to ask at a deposition. How often do you remind your people to read the policies and procedures manual, et cetera, et cetera? Just flip around what I just said, but from the plaintiff standpoint, and you'll see that that benefit can come up, that the manual can be, it can also be a dagger if you have that, if you don't have the language in there, or if it's undefended, or if it's not augmented by other programs within the company, or if it's passive, if it's just language that is sitting there. But assuming that the company does have a rigorous program of enforcing its manual, it can be a very effective defense tool.
Yeah, that's a great point, Malvin, on that same issue. If the company has had other claims in the past of harassment of a similar nature, or maybe by the same trader, and how did they respond to that, right? What did they do? Did they mitigate? Did they, force that person to undergo some kind of courses or training, or behavioral training, et cetera? That could become relevant in a lawsuit, in a later lawsuit, and that the company would want to say, yeah, we had a past issue, but we right away addressed it, we mitigated it, and here's our policy, and we clearly don't condone this kind of behavior. So there's all kinds of documentary evidence that can become really critical in a punitive damage side of the case, along the lines of what Malcolm's talking about. So don't forget about the most mundane, policy and procedurals manuals and handbooks and training guides and the like, because those can be front and center in one of these cases, if you're on the defense end, if you're on the plaintiff side as well.
Yeah.
All right, let's go to our next slide. So now we're kind of getting into damages, determining punitive damages under both of these two jury instructions that we've just kind of walked you through. How do we determine if there's going to be an award of punitive damages? What factors does our Supreme Court look at? Does our California courts of appeal, what do they look at? Are they different? Are they similar? And then also, what about numbers? What are sort of the ranges that courts permit? What's considered constitutional? What's considered unconstitutional? And what are the different ranges? So that's sort of what we're going to be getting into in this next section. And it's really, there's a lot of meat on the bone, I will say, as Malcolm and I have discussed. And so this is where I think it really becomes pretty interesting, and where we where we may need more time with you all.
Let me also, as an introduction, Lynn, I like using the example because I've done it before, is that there used to be this this commercial that was on TV for some laxative, right? And they're saying, well, you need to use a laxative because, oh, I'm just so confused. Is 3 enough? Or is 6 too many if I give the kids prunes? Okay, is 3 enough or is 6 too many? To our listeners and viewers, the question here and the applicability of that to this is, how many, ask yourselves this: what do you know right now about the constitutionality of the punitive damage awards? We see them in newspapers. We hear about them anecdotally. We hear about them through the Bar Association. We read about them in the journals. The question is, how many of you know is 1 times punitive damages the limit, or 3 times, or 5 times, or 10 times, or 20 times? How much can somebody punish a defendant for conduct if it's proven, as we talked about before? What are there limitations? And if there are limitations, what are they? I'm sorry, I just wanted to give that little
No,
preamble
that's
there.
so important. And also I'll just throw in one more for you, which is, who decides? Is it the judge? Is it the jury? Can it be either one? Who makes that determination about the amount, about whether they're awardable and the amount, right? Everybody's
Yeah.
most interested in the amount because it becomes so salacious in a lot of these cases. And you will often see, just for the audience's edification, you will often see where there's a remitter. So the juries often come back with these really high numbers in the punitive damage space, and then the judge will do a remitter. That's pretty common, I think, in the cases we reviewed, getting ready to do this presentation for everyone. I think I saw that in almost every case. And the reason that the courts do that is that they're getting the numbers within this sort of constitutional realm, which we'll talk about what's been acceptable in terms of multipliers. Is 3 times your compensatory damages for punitive damages, is that okay? What about 7? What about 9, 10? It's interesting, and we see a variety of conclusions that are reached in the cases. So with that in mind, why don't I go through the next slide, and then I'll turn it back over to you, Malcolm, if that sounds good. All right, so element 1, this is the reprehensibility of the defendant's conduct. And this is really where a lot of the cases, particularly the Supreme Court cases, both the state and the US Supreme Court, focus their attention, is on the reprehensibility of the defendant's conduct. And one of the cases, and I can't remember which one as I sit here, basically said this is the most critical factor that we look at. And so, this kind of comes out of the Supreme Court seminal case of BMW versus Gore. And you may remember that case from law school or from practice, but it's a case from the mid-90s where the US Supreme Court actually set out 3 guideposts that courts are supposed to follow and consider when they're determining whether punitive damages should be awarded. And just to keep this in mind for our conversation, those 3 guideposts are, number 1, this element here, the degree of reprehensibility of the defendant's misconduct, and we're going to get into what that means. The second guidepost that the courts consider is the disparity between the actual or potential harm that's suffered by the plaintiff and the punitive damage award itself. And then third guidepost is the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. Those are the 3 guideposts, but again, I would just emphasize for you that this number 1, this element 1, is really where the cases seem to focus. So what does that mean? How reprehensible was the defendant's conduct? Courts will look at a variety of factors to decide, or juries will, whether the conduct was reprehensible. And the first one, I think 1 and 2 are the most key here, but the first one is whether the conduct caused physical harm. Again, think about the rollover cases where people became severely injured, they became paraplegic, some died. think about cases where somebody's exposed to a chemical, asbestos, they develop mesothelioma. These are the key sort of hallmarks of reprehensible conduct. That's number one. Number two is whether the defendant disregarded the health or safety of others. And this is kind of aligned with number one. But I think the best example of number two is, I mentioned the Monsanto case earlier, and that's a California Court of Appeal case from sometime in the 2000s. I don't have it in front of me, but I will get you the site. In that case, there was actual evidence that the chemical used in Roundup could cause harm to humans, and the company knew about it. They knew about the studies, they knew about the science, but yet they tried to shift the narrative when they were talking with the EPA. Oh, it's really not that bad, and here's another way to spin it, and we're going to kind of not talk about these studies, kind of cover up, right? That's really, I think, what factor two is getting at. And just for everyone's reference, the Monsanto case is Pilliod, P-I-L-L-I-O-D versus Monsanto Company, and that's at 67 Calat 5th 591, and it's from 2021. I think that's indicative of number two, is the disregarding health and safety of others. You knew it was dangerous, and yet you didn't do anything about it. You didn't put a warning on that product. You buried the evidence, you buried the science in the journals, so people couldn't know, they couldn't find out. So the third factor that the courts consider when they're looking at, is this reprehensible conduct, is whether the plaintiff was financially weak or vulnerable, and whether the defendant used this to take advantage of them. There's a case we're going to look at where a veteran who had pretty severe medical conditions, was in a wheelchair, required a lot of medical treatment, was denied health benefits. Now that is, I think that goes right to number three here. Somebody who's financially weak, they're a veteran, he was unable to work, and yet a company, an insurer, is denying his health benefits. And that's an example of that one. And then fourth, another factor that the courts consider for the reprehensibility aspect is whether the conduct involved a pattern or practice. This is also really important. Typically, where you have corporate entities engaging in misconduct over and over and over and not remediating that misconduct, that is going to be a hallmark of reprehensibility in the court's eyes. I think in the Ralph's case, it sounds like from what Malcolm was sharing that Ralph's did take some remedial conduct to address these claims of harassment and so forth. But where you have really salacious facts where, a company's been accused of, let's say hostile work environment, discrimination, harassment over and over and over again by different employees, and they don't take action to correct it, or they don't have a policy in place that even addresses it, that's going to be factor number four, and it's going to go to the reprehensibility of the misconduct. And then finally, whether the defendant acted with trickery or deceit. Deceit there, that's really, aligned with fraud. I think there's some overlap with that. Trickery, this is sort of, to me, sounding more in fraud. But here, I think the real key ones are the causing physical harm, disregarding safety of others, rights of others, and involving in a pattern or practice of misconduct. So that's element one. I'm going to turn it back over to Malcolm. I think this is actually the most exciting one, I'll just say. When you're reading the cases, you can really see some interesting and varying degrees of misconduct.
No, Lynn is right. It is the most exciting one, and that is why Lynn was the one who introduced it, because she can do it much more excitingly than me.
I stole it from you, yes.
You did, but that's fine. My pleasure. By the way, for everyone's benefit, I sent out in the text the citations to both Monsanto and Ralph's. So if anybody missed the sites as we yelled them out, you will be able to get them. I scribble them down if you're interested in reading either one of them. We're closing in right now on an hour, on our first hour. And what I wanted to do is let me give a little bit more of a discussion of this factor two, and that may be the breaking point for us before we get to our final element and then our examples. It's going to be even more exciting than this session, because we're going to actually delve into several examples. But I did want to say one thing, and I'll say it right after. Let me get through factor two right here of element one, and we'll go. It says plaintiff should seek evidence showing defendant knew the risks and chose to proceed. Defendant attempted to hide or combat adverse studies. Defendant did not adequately disclose contributions. These are, Lynn said it, and I think we should keep saying it. It's the F word, fraud, fraud, fraud. Is there a misrepresentation? And the other one is the K word, knowing. Those are the two things that you should be looking for all along. Is there anything that you can characterize as fraud? Or if you're on the defense side, the question is there anything that you can do to mitigate that this was a harmless mistake by you, even if it created harm, and that it was something that it was unintended, unexpected, and it cannot be perceived. So that's going to be the important, that's going to be the fight, the clear dividing line when you go to court. It's interesting because I'm going back to the Ralph's case very quickly. The reason why I find it so interesting is that Monsanto is a really ugly case. When you read Monsanto, you think, well, what jury could conceivably ever find that Monsanto acted properly? In the Ralph's case, you sort of go back and forth between the behavior, and we're not talking about the perpetrator, the manager. We're talking about Ralph's itself and Ralph's conduct and Ralph's attempt to mitigate the circumstances and deal with the manager. At that level, it's more nuanced, and most of the cases that you are all going to be faced with are going to be more nuanced. They're going to align themselves. If you have a slam dunk case like a Monsanto, then you're in pretty good shape, because then you can turn to the next section of what we're going to be talking about, and you can then focus on how are you going to enhance the constitutionally allowable amount of punitive damages that you would like to get. And if you're on the defendant side, you're going to say, wait a minute, how do I mitigate this conduct so that we go to the lower end of the constitutionally appropriate punitive damages, so I can argue a lower amount. So the issue here and by the way, what I wanted to do is stop for 1 second through that narrative. Do we have any? It does not look like we had one Q&A, and I responded to it. There's a question regarding a citation, so I dealt with that.
Oh.
I don't see a further question. So we have 3 more minutes, so let's keep going. We're going to keep you all until the very end. Go ahead. Let's
And
go
if
to
you
the
do
next.
have a question, feel free to put it in the chat, and we'll see that, and we can
Sure,
respond
absolutely.
either today or part 2.
That's part 2. Whenever that is on a date to be determined. So we don't know. We can't tell you what it is now. So watch your emails. Let's have the next slide. Okay. Whether defendant disregarded the health or safety of others, how to defend. The defendant did not know that their conduct had probable dangerous consequences. The thread that I see through all of the cases that are cited, as well as the citations within Monsanto, and looking at the other, some of the seminal cases, including the U.S. Supreme Court standard that we had, is that when there's a physical harm of some sort, if there's a physical damage to someone, if there's an injury to someone, it is more likely that you're going to be at the upper end of the punitive damage constitutionally allowable stage of damages. If it is not a personal injury of some sort, then it's more likely you're going to be at the much lower end of the punitive damage scale, even if the jury finds that punitive damages should be awarded. And one of the cases that we have is the BMW case, and that's an interesting case because the jury awarded millions of dollars of damages where a car was repainted without telling the buyer of the car that the car was repainted. And so they said the court just sort of slapped the jury a little bit by saying it was so way outside the realm of any constitutionally allowable damages, because the actual damages for the vehicle were something like $35,000, but there were millions of dollars of damages for it. And of course, the court then said it was a minimally reprehensible level of conduct. So I thought that language, it's very interesting. We think of reprehensible as either reprehensible or not reprehensible, but not so. There are levels of reprehensibility, and you need to think about that. So since the jury said, yes, we believe in punitive damages, the short story is that they went far and above, but the theme was from the Court of Appeal that they awarded those damages because they were very upset with the dealership's conduct. Probably all those people bought a car at some point in time, and they were all lemons. So that jury wanted to punish the automotive industry. But the reality was that it was a car. Nobody got hurt. It was paint. It wasn't hiding what was going on with the fuel injection or the brakes or something else.
It wasn't a rollover, yeah, right.
No, it wasn't a health and safety issue. So since it was not a health and safety issue, the court basically gave what I call the "oh, come on" defense, which is they said, "Oh, come on, you're not going to award that kind of punitive damages in this kind of a case where you can't, where the jury should not have been inflamed as much as they were to make that award against BMW." So I think that takes us through. I will say that on this case that's coming up, we're talking about medical and scientific developments discovered after a plaintiff's injury cannot establish that the defendant knew of the probably dangerous consequences of their conduct. One last comment before we conclude the session. In the Ralph's case, the plaintiffs tried to bring in evidence of things that happened at Ralph's after the period of time when the plaintiffs were affected by the manager's misconduct. And the court said, no, you measure punitive damages at the time that the conduct occurs, not based on subsequent conduct. So you cannot use subsequent conduct. And yes, you would probably file a motion in limine, as we were talking about earlier, in order to keep that kind of evidence out. But I also wanted to make sure it was clear that I was not the plaintiff in this case. This is McNeil spelled differently. I don't know who this guy is, but who sued Whitaker, but I just want everybody to know it's not me. So I think then should we stop there? Do you have any concluding
I think so. We do have
comments?
2 questions, it looks like, in the Q&A, so we can either defer those till next time or try to answer them. If we still have a couple of minutes, they're pretty straightforward, I think.
If you'd like to answer them, go ahead.
Yeah, I think so. The first question is, does the clear and convincing standard come into play at all during motions to strike punitive damage prayers? Or is that only substantively used at trial? Based on my experience, it's substantively used at trial, that standard, clear and convincing. On a motion to strike, that is typically not the standard. The judge would be looking at whether the plaintiff has stated sufficient facts for a punitive damage prayer. So have they stated that, the defendant engaged in fraud, malice, oppression? Are there enough factual allegations made? But there's no proof standard that's applied at the motion to strike phase of the case.
And I'll field the second one. Jordana Thigpen asked the question, what about the fact that BMW, the plaintiff, brought up the harm which was occurring nationwide, that the painting issue came up with numerous people, which made it reprehensible? Is it accurate that numerous cases have since held, including California, that is appropriate to mention pattern and practice? Pattern and practice is something that is an appropriate it's appropriate evidence to bring up, but in conjunction with what the defendant knew at the time that the punitive conduct occurred in the case that's before the bar. See, because if it's after, so if there are 39 cars that were painted beforehand and they show course of conduct, etc., I think that would clearly demonstrate reprehensibility and would in fact be admissible. But what if the pattern occurred after this particular incident? At that point, I think the court would properly exclude that evidence because it wouldn't go to the punitive aspect and the conscious disregard of the defendant at the time this particular incident occurred as to this particular plaintiff. So that would be my thumbnail analysis of that. Thank you both for those questions at the end.
Whole
we
question.
shall say thank you for coming. See you next time. See you for part 2.
Thank you
Bye-bye.
all. We really appreciate it. And we'll look forward to part 2 with everybody.